Hello guys, my name is Duncan Wilson. I am a mortgage broker. Been mortgage brokering for quite a while now, and I won't tell you the number of years. Right now in the market, guys, I know there's a lot of worry going on. And the main topic today is, do I refinance? Do I do a proposal? Or do I perform a bankruptcy? So who I brought in today with me is the Andrea Orr. Tell me what you do.
So I'm a licensed insolvency trustee, and I help people that are in debt, whether it's a proposal to the creditors or a filing of bankruptcy. A licensed insolvency trustee is what you need to get legal protection from your creditors.
On my side, I don't offer any of that protection. I just pay out those debts with a refinance of your equity for your property. So I think we should go into maybe what's the major differences of where somebody would come to you as opposed to going to a broker to pay out their debts. What do you see most times people coming to you for? I'm assuming they don't have mortgages or they don't own a property.
Well, people come to me when they typically aren't able to get a mortgage.
Okay.
Or if they just don't know what to do. A lot of times people do own a home and they don't know what to do about these debts that they can't pay. They've got their house, they've got a mortgage, but they've also got credit cards and lines of credit and car payments.
And they're stressed.
And they're so stressed. So what we try and do is explain to them that you're going to keep your home, so that's off the table. But what we've got to do is try and access the equity that you've got in your home to satisfy these other debts that you're having trouble paying. And by equity, I mean if your house is worth 500, your house is worth 500, and your mortgage is 300, then that means you have 200,000 in equity in your home. And when we see that, we say, okay, you need to go see Duncan, and he's going to help you raise some funds against that 200,000 equity so that we can then settle with these creditors who are harassing, causing massive stress.
I would say it's a high stressful situation that you're most likely in if you aren't paying your bills on time. Sometimes these debts, like I've had stories where these debts aren't even the person that belongs to them. They've co-signed on a credit card. When does it happen where a client, for instance, can't do a proposal?
That can happen, yes. Although if they are unable to pay their debts as they become due. That's sort of the magical expression that's used. They can still tap into the equity and offer a payment to the creditors, but clearly it's going to have to be a payment in full over time. Lump sums are always preferred by the creditors. You've got to offer a little extra over that period of time for those creditors to agree to stop all collection efforts. Because keep in mind that these creditors, when you don't pay them, they have legal rights to collect. And they usually start by launching a lawsuit. Well, they start with collection calls, and then the legal papers come. And then the court hearing comes, and if you're not there to defend it, which is most of the time, because
99%.
How do you defend that you don't owe the money? Then
or
they
you
get
might
it.
be working that day because you're trying to pay
maybe,
bills.
or like a lot of people, you just put it aside and hope it goes away.
Oh, like the head in the sand.
The
situation.
head in the sand is so common. So, but once they do get that judgment, eventually they're going to enforce a judgment, and that's not collection, that's legal action. So that means garnishing your pay, and it also means putting a lien on your home. So before it gets to that stage, you've got to talk to a trustee.
Because they protect that from happening. Where they have their head in the sand, you're the person that's sitting there going, okay, don't worry, we're going to communicate with all of these creditors and whoever you owe money to, and we'll start organizing them so they understand. The creditors listen. They're like, okay, they're now being represented by you.
As soon as you file with a trustee, the trustee issues something called a stay of proceedings. Everybody stops in their tracks. So no more calls, no more letters, no more lawsuits. Wherever those creditors are in the process, they're frozen in time, and the trustee takes over. So that's the big benefit of using a trustee, because you get that legal protection instantly.
She's not saying, I'll wipe all your debt free and clean. It's not like that, guys. It's getting protection against your creditors. If you do notice that you're behind on your debt payments or you can't make your debt payments, your first thought should be to call Andrea Orr. If you call me and you're already slightly behind on your debts, I'm going to tell you that your rate's going to go up. Sometimes you might get a decline. and we may have to go private. So my best shot and my best idea here would be to send you over to Andrea Orr to talk first about your debt protection. So just understand, this is not wiping your debt clean. This is an actual protection measure against you as a borrower. And she talked about a lot of people with their heads in the sand. It is probably the biggest issue we have. And the biggest saying is, in our industry, is no one's dying. You can't die from having a ton of debt. The funniest thing is people put their heads in the sand for medical reasons too. If you're ignoring these situations and I guess financially you're not healthy, don't ignore it, guys. Don't stick your head in the sand. I'm going to actually ask one more question. We're talking about lump sum proposals. Go into the difference between a bankruptcy and a proposal. I mean, I've been around for years, Andrea, and I still don't technically understand it myself.
Yeah.
I know bankruptcy is like the big B word, and I know we hear about it in the States called Chapter 11.
Well, actually, in the States, Chapter 11 is what our equivalent would be for a proposal.
Oh.
And Chapter 7 is a bankruptcy. Now, we don't use those terms. Before you do a bankruptcy, a trustee will first review with you the option of a proposal. So a bankruptcy is typically filed when you have no assets, you have very, very little income, and you just simply need to have protection from your creditors. Someone with an asset who files for bankruptcy, it's a lot more complicated because the trustee has to take the equity from those assets and realize on them, whether it's sell them or collect a payment over time within a much quicker period of time than is afforded by a proposal. For example, if you were to go bankrupt and you had $20,000 equity in your home, your trustee has to collect that $20,000 within a couple of years. If that's not done, then the court gets involved and there's court orders that require you to make the payments. It gets complicated, it gets messy, it gets expensive. Rather than doing that, the proposal option is, all right, instead of doing the bankruptcy, let's take that $20,000 and maybe we'll increase it to $22,000 and we'll offer it to the creditors over 5 years. The trustee is collecting that debt over time in the proposal, and it's very organized, and the creditors can rely on the trustee to collect it. That's the difference from a practical perspective. From the credit bureau side, when you file a bankruptcy, they issue an R9.
Correct.
Okay. And then that bankruptcy stays on your record for 6 years after your discharge. Mm-hmm. Sometimes a discharge can be achieved in 9 months. Sometimes it takes a couple of years. Sometimes it takes 3 years. So once you're discharged, then you get that 6-year period of time starts. To annul a bankruptcy means the bankruptcy never occurred. And there's really not a lot of reasons to do that. One example would be if you won the lottery and you were all of a sudden in all kinds of money and you don't want a bankruptcy on your record. So you have to pay all your debts in full. You've got to pay a 10% premium, which is what the statutory amount is. You've got to make sure your trustees' fees paid. And then you go to court and you ask that the bankruptcy be wiped out from your...
But can they not go after you?
No. So what I think what you're referring to is when someone files a bankruptcy and then disappears from the trustee's radar. So what happens is the trustee does his or her job, and at the end of their job, they get a discharge. You know, I do my paperwork and I file all my things, and then if you've disappeared on me, well, I still have to be discharged as your trustee because I have obligations as a trustee. So I get discharged, leaving you undischarged. That means your creditors can come right back at you. When I get my discharge, the protection is discharged with me.
So it's gone.
So you're done.
Guys, I hope you're listening to this. If you have debts out there, and I'm not talking about the $500 Visa card. We're talking about numerous debts where your cash flow is not as good anymore, and you just want to get rid of all these debts to maybe live again. Maybe not have the stress of them being on your shoulders constantly. I hope you're listening to everything Andrea is saying because it does make sense. Sometimes you cannot handle your debts, and I want you to, lower the pride. A lot of them come in and see me, and I'm saying, okay, we need to kind of go see a trustee. Let's go talk to Andrea, and you don't want to do that. Don't be afraid to just talk about this, talk about solutions. Debts are higher than I've ever seen in my career. You have a lot more people coming in nowadays, and I think it's going to get worse because you talked about one thing. you go bankrupt when you have a ton of debt and you had no income or no house. Who gave that credit card and that debt to this person? We all know who it was. One of them's like, just throw that out there. I know Maddie's going to edit this out after. But there's credit cards out there that are given to clients with no income. It doesn't take a lot to qualify for a credit card. And the reason why it's so high is because it doesn't take a lot to qualify to get approved for them.
I think one of the major issues that we have as trustees is that we're not allowed to put an ad on Facebook to say, I can wipe out your debt. I can turn 100,000 into 6,000. I'm not allowed to advertise like that. Yeah, I mean, we certainly can through a proposal, but we're so controlled by the federal government over how we advertise that it's made consumers fear us.
I know what you mean. Like when I'm talking to Andrea Orr, I'm actually talking to the government, and I don't want them knowing my situation or my scenario kind of stuff.
Yeah,
like
maybe that's the
thinking. Authoritative role.
Maybe that's the thinking.
And I don't even know if we can mention the fact that should we talk about it? But like CRA, I've seen 2 or 3 proposals you've done where CRA back tax arrears are inside this.
Yes.
And I've been told, oh no, that can't happen. Yeah. And my whole career I've been told that can happen.
Seems to be a lot of experts out there who seem to think that CRA is special, and they're not. Just because CRA is part of the government doesn't mean that they're not subject to the laws that are come into play when there's a proposal. So when we as trustees look at the creditors, we look at credit cards, lines of credit, CRA debt. They're all equal. So income tax, CERB, EI overpayments, all of those debts get treated just like your Visa card.
Wow.
There's no special treatment. You're not stuck with them. However, debt advisors advertise on Facebook.
There's debt consolidation companies where they're not actual trustees.
Right. So they will work with people, package up the information, and then send them to a trustee, because a trustee is the only one that can actually do the proposal.
Yeah.
The big issue is, or misconception is, that you could go to a paralegal to compromise your debts. Credit counseling is another one. That's a legitimate debt consolidation forum. However, none of them will be able to compromise CRA. Only a licensed insolvency trustee can address CRA debt. So you have to go through the proper process, the statutory filing with a trustee in order to get the true protection. Yeah.
Is there anything else like you want to add?
Well, when you were talking about the bankruptcy, there is another area where people do have to do a bankruptcy, and that's when you try to file a proposal with your creditors and they just won't work with you. Doesn't happen often, but it does happen. Typically, if you've exhausted the proposal option, you're kind of looking at bankruptcy as the next step, because you need the protection. When you file a bankruptcy, the trustee has to collect a percentage of your income. And those payments can be quite substantial, depending on the amount of your income. So it's not as easy as when you do a proposal. A proposal typically takes the payments that you would have had to make in the bankruptcy and stretches them out over 5 years. So it's just more affordable. It's better for your budget. So that's another kind of angle to look at.
Thank you so much for coming in today, Andrea. And let's get this done.